Welcome back. Welcome. We are still docket watching and celebrating 10/10 for Sarah Boone. And Judge Jackson, where are you? We're looking for you. Join me as I pillage through Sarah's case and find out how we got here in the first place. No malicious content.
Meanwhile, let's watch as the deranged team try to deceive the court.
It's going to come down to me.
What do you mean?
So it's being put on me. What's next?
They're going to come and swab your fingers.
No, I'm talking about, in the long run. What do I need to, do I need to be doing something, or,
I can't tell you, what to do.
I mean, I don't understand, I don't know if you guys are just going to, because it makes it sound to me, I'm being accused of something that was not intentional. I'm being accused of it.
Mm-hmm.
And a handful of other things that I'm being accused of.
Okay.
So I don't want to be at home with Lucas and you guys show up.
Okay.
I understand that.
So
we're still investigating. I don't know what you want me to tell you.
Had to talk about that, referring to the autopsy.
By Sevens.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection. Best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection. Relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection. Proper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled is relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection. Proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013.
How long have you been a homicide detective?
Over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection. Relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection. Relevance.
Overruled.
I did not ask her question number 9.
Okay.
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
You were impaired by alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct?
Correct.
And you consumed no alcohol in your home that morning, correct?
Correct.
So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon? then.
Did alcohol affect my conversation with her?
There's a jury instruction that says a witness's memory and perception is pertinent. And I'm asking you, did the alcohol that you were under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she didn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she had said she didn't know what.
What are the legal grounds of your objection?
I'll withdraw it.
All right, you may proceed.
All right. And you understand that you're charged with second-degree murder in this case, correct? You're facing a potential penalty of life in prison, correct?
I understand.
Do you understand that the score sheet minimum is probably about 22 and a half years?
I don't know.
Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than you have testified in the statements in State's Exhibit 1, correct?
Regarding the...
I would object to that. I'm not understanding what the question.
Mr. J.
Judge, a witness's bias is always at issue when they take the stand, and it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copsel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon. We're simply asking her what she said that was different, and obviously if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
You gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted?
Of course.
No.
If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues that are pertinent to the court's analysis, which the state would submit there is not, because we are conceding there was custody on February 25th. They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited. But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's, and of course she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow.
Okay. Just make sure. Or what we tell his parents. What do you mean?
So, and that couldn't have been because of him being in the suitcase. Or now you all think.
Yeah, that's when you do it. You shook me. Carol.
I don't want to watch it, please. Okay.
Last time we talked to you, you had said that you put him in the suitcase, he had 2 fingers hanging out.
I flipped him over. I flipped him over, and that's where it was.
There's 2 different videos and a still picture where, yeah, it shows you flipping him in different positions, and him saying that he can't breathe, and you saying fuck you.
So this is upside down. To do it, just so you know. So don't think that it's.
I don't have a problem.
Okay. Just make sure.
So, am I getting my phone back?
No.
Not today.
What about Lucas's laptop?
No.
Not today.
Not today.
What does that mean?
We're still going through everything.
Oh, that's fine.
You're the one just telling us there's videos that we need to see on it, so we need
That's
to
fine.
do our due diligence that we go through everything.
See, and that backfires on me now, too, because now you all think that I had even more, in quotes, intent to do what I did to him, which was not intentional.
What's that?
In that. Is that correct?
She's asking about your tag in your hand.
No, but I'm asking if that's correct.
No, I'm not going to
We're not
agree to
making
anything that you're saying. I'm not, that you're... No.
So, his probation officer,
Mm-hmm.
do you all inform her, or do I need to call her?
We don't have to inform her, so if you would like to call her, you can. Are you saying because he's still on probation?
No, but because of the nice lady that she is and all that she's done for him, I didn't know how it was.
Legally, we just have to tell his parents, and we don't go telling.
Everybody else?
I didn't even know who his probation officer was, so no, I wouldn't go tell.
So the same thing for classes. I need to do that too.
Classes?
The
You need to do what?
substance abuse class and his batter's
cancel him?
intervention.
Yeah, we
Something
don't
else I
have
was
to
just
call
getting ready to
him.
ask. So, other than this, so initially, what was the cause of death?
She is still pending because she wants to hold the body for an additional day to see if more of those bruises turn into something bigger. And she's doing some other tests that she's got to do. So she's pending it for now.
So, and that couldn't have been because of him being in the suitcase? Or y'all are saying that I physically did it?
That's what she's determining.
So,
The ones on the head, I asked her, could that have been from the suitcase, and she said she didn't think so.
I didn't touch him, nor did he touch me.
Okay.
Court pronounces sentence as follows. Ms. Boone, Court sentences you to life in the Department of Corrections, with credit time served that Madam Clerk will provide to you momentarily. There are also court costs and costs of prosecution, which Madam Clerk will give you the totals of.
What does it matter what we tell his parents? What do you mean?
Because
We're gonna talk with them.
Yeah.
okay,
I have to
but it's
tell-
going to come down to me.
What do
Gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't.
All right, after the puzzle, what did y'all do?
I decided to continue to maintain and focus him, and I have a bunch of paints that I used of my son's that his grandmother bought him. It's a very big art wooden box, and it's got pastels, pencils, paint, any kind of whatever. And he and I were very much into art, and with this resource, it got him very interested in being more creative.
How long have you been into art?
Ever since I can remember. As a child,
You like to draw?
I like to do anything artistic.
And I
continue to come into the prison system and be allowed to continue to break the rules, they haven't learned anything. So yes, we do have a discipline process. Yes, we enforce the rules. Is it a hellhole? Is it the worst thing in the world? No, ma'am. It is not in any way.
It has been revealed that Sarah is now classified one level below death row. We know she's sentenced to life and will possibly be in a single cell, meaning no roommate. I do believe this to be a harsh sentence. However, she worked really hard at earning it. Before and after her arrest, she displayed her zealous and keen abilities to weaponize the judicial system at the drop of some wine. I mean, Sarah played subject matter jurisdiction level games with the court. I believe they are giving her no wiggle room under the jail, like she wished for George. While this will be a stark contrast from the prior time Sarah spent hanging out in the Big Bay at Orange County Correctional Facility, this is serious. They are locking Sarah down under close management, confinement of an inmate apart from general population for security reasons, where the inmate, which in this case is Sarah, through his or her behavior has demonstrated an inability to live in general population, and that means hoarding cheese, starting fights, manipulating staff. Basically, abusing the rights and privileges of others.
Know that.
I don't.
Know that.
See, what Sarah did not realize is reception was not the beginning of her evaluation. Her evaluation began at the inception of this whole suitcase incident. That never happened before. Every 911 call, every interaction on body cam, her interrogation, the video, the courtroom games that she played, manipulating the system, actually weaponizing the judicial system, going as far as the judge, getting top attorneys that were there to help her.
Somebody had to do it.
To remove themselves from her case, even at her detriment. All of that was being documented. Even while she was at the Orange County facility, every game that she played, every rule that she broke, it was all being documented. By the time she got sentenced and went to reception, everything was there in black and white, and she was a clear security risk. Immediately sucking her in a vacuum away from all of the fun that she was having in the Big Bay. So now Sarah will be sitting for the rest of her life alone. And how ironic is that is the same exact fate that George suffered. Everything that I saw Sarah say about George, She's literally living it right now.